Good. So welcome to this mediator meeting. I mean, just to give you a little bit of context, conflict dynamics has mediator meetings in the main centers with the aim is twofold. Firstly, to see each other and meet up with each other, because all our panelist meetings and mediator professional development sessions happen online these days. So we miss out on really actually engaging and chatting and getting to know each other as mediators. So that's the reason we have these meetings, mostly here and in Cape Town. So yeah, that's the reason we're having this meeting today. The aim of the meetings, the in-person meetings, is to network, as I've said, and secondly, to speak about developments in the industry. So we often speak about new markets, potentially speak about new developments, and that's really why we've chosen the topic of professionalization today. So this isn't a new topic. You all know that we've been speaking about professionalizing the industry for a long time, and a lot of work has actually already gone into that. But it's a very topical issue at the moment, because we're very interested in knowing how developments elsewhere have affected this whole professionalization discussion. Great, excellent. Yeah, so just to give you a sense of why it's become so important, the topic of professionalization is questions have been being raised as to whether there's been an increase in the number of mediations that have taken place since Rule 41A came into being, which is now, over 4 years ago that rule came into place. There's some people who argue that sort of anecdotal evidence that there are a whole lot of mediators out there who are mediating and are not accredited mediators and are giving the industry quite a bad reputation. So there's a concern about that and how important professionalization is. And there are also comments that we hear about judges not wanting to enforce the rule because they're exactly that. They're concerned about the level of the mediators that are taking on these matters. So it would be very interesting to hear from Hendrik and Roland what their experience is in terms of that. The other sort of development is that the Law Review Commission, the South African Law Review Commission, is progressing towards writing up an act and is in the process of that. Hendrik is involved in that process. And it's important to understand where we are in terms of that and what pressure that will put on us as mediators sector. Yeah, so that's really the rationale for why we've called this meeting today and want to hear more, so to speak. We've got two guests who are going to kind of give us the information. Firstly, Hendrik. Hendrik is an advocate and I think more appropriately a full-time mediator. He certainly keeps us busy and we keep him busy, and is also one of our lead trainers on our program, so we work a lot with Hendrik there. But more importantly, in terms of this meeting today, Hendrik was involved in conceptualizing DiSAC, which is the voluntary professional organization of the mediators in South Africa. So, Hendrik, I think you'll give us the timeframes, but I think you probably started thinking about that a good sort of, I would say 20 years ago.
2008, 2000.
Yeah, that gives us a sense. Yeah. So you conceptualized that and you established that DiSAC, and just for information purposes, DiSAC is the voluntary, the only really existing voluntary professional organization at the moment. And Hendrik and others in this room and on screen, John and Felicity were also involved in that. We're very involved in establishing minimum industry standards for mediators. So speaking about how you get trained to be a mediator, how you get assessed and accredited, but also then issues around supervision of mediators, disciplinary processes, codes of conduct, and continued professional development. So they were involved in thinking through that whole structure, a long time ago. And Hendrik has also then been involved in trying to push that forward and consult that through all the organizations, the mediation organizations locally, towards establishing a SAPO accredited body. So we look forward to hearing about all that work and your work on the SL Law Review Commission as well. Roland, on my left, I met Roland in the early 90s. He was a mediator at the time. He was trained in 1987 as a mediator, so that's a long time ago. And he's obviously been thinking about this mediation thing for a long time too, and has also been able to think about it from a different perspective, as he is the Deputy Judge President of the Gauteng High Court, and has been really the face of Rule 41A and what's happening there. We've had Roland here before to speak to us about that. So we really look forward to hearing from Roland today, because as the most senior amongst his peers there at the Gauteng High Court, he's also in a perfect position to inform us of how mediation is being seen by them and how it's being, how the busiest court in the country really is trying to deal with mediation. In terms of Rule 41A. So we look forward to hearing about that. Roland, we also know that you've very focused on the efficiencies of the court. So it's going to be very interesting to know whether mediation has had an impact on that. And, if there's anything we could be doing to assist in terms of assisting with those efficiencies. So I think we're in very, very good hands to have a fantastic input, really. Each of the speakers are going to speak for about half an hour, and then we're going to throw the floor open for questions and really just have a conversation on these topics, these and related topics, I'm sure. Great, thank you. Good, I'm going to hand over to Hendrik first. Hendrik's going to give his input first. Could you keep your questions just so that we can really get the most out of the time we have with them? If you have any questions, just make a note of them, and we'll give you an opportunity once we've heard from both our speakers. Thanks.
Thank you, Marion. Thank you, and good afternoon to everyone. Thank you for introducing the topic also very comprehensively, Marion. I think you set the stage very nicely. I would like to just take a couple of minutes and just kind of focus on what we mean when we talk about professionalizing mediation, just so we have a sense of being on the same topic around that. Now, if you look at the writings around professions and about professionalizing and an area of practice, there are certain standard features that people generally accept are contained within that concept of professionalization, and those are clear, uniform criteria for entry into that profession. And then usually a criteria is prolonged and formal training as for a qualification that provides you entry into that area of practice. Then an established code of ethics to which people subscribe, and then ongoing uniformity and harmonization of practice standards within that area of practice, and then some mechanism of oversight and accountability for people practicing in that area. And then the final component is the one of kind of authority behind those mechanisms that provide that oversight and accountability measure. So if we take that kind of as the basket of things that we talk about when we talk about professionalization, hopefully that helps to set the scene as well. Now, before we get into the details of professionalization of mediation in South Africa, I think it's also useful to ask the question about why would we want to professionalize mediation practice. Now, I think the the first thing is that, and most of us probably come from some form of profession already, a legal profession, the psychologist profession. Lots of us do have another profession over and above the mediation work that we do, and I think most of us would admit that there is a component of stature that's given to you to be a member of a profession. It gives you a degree of recognition and authority to do the work that you're doing as a professional. So in that sense, I think we're all at a personal level interested in being part of something and being given entry into something that is recognized as a profession. I think the questions that I want to ask today is whether we're all prepared to also take the obligations that come with being part of a profession like that. Some of the things that I've already mentioned as being part of the content of that basket of professionalization are qualifications. It is kind of what is the career path within that profession, and it's the whole principle of accountability. So if we want to be part of a profession, those are some of the things that come inside that basket that we call professionalization, and those things have implications, and I will come back to that a little bit later and just unpack what those implications are. I think a second reason why we do want people to consider professionalizing a practice area is that it provides a degree of protection, both for those within the practice, because face it, professionalization barriers provide barriers to entry for people practicing in that area of practice. So by establishing a profession, you are excluding some people from performing that profession. So in that sense, being a profession provides protection to people who have passed the qualification or the experience barrier to be inside that profession. Now, why do we want to impose that barrier? The argument is normally that barrier is imposed because it also provides protection for the public out there. People who want to use mediation services are expecting a certain standard of service, a certain degree of expertise and qualifications when they approach a mediator. And by professionalizing mediation, we are, in a sense, giving the public a degree of a guarantee to say if somebody has passed that, come through the gates of the profession and been recognized as a professional, there's a stamp of approval on that person to say that they know what they do. So that protection, yes, it is a barrier to entry for people coming into the profession, but it's normally seen as a justifiable limitation because it serves to protect the public out there and give them a sense of guarantee that there is quality service. If you read about professionalization and also specifically around mediation around the world, then what tends to happen is that professionalization becomes a focus and becomes very important when the regulatory environment starts developing to a point where you require some degree of distinguishing between who is a qualified mediator and who isn't. And I think, Marion, you already alluded to some of that. We're already now in South Africa in a regulatory environment where legislation, where court rules are already prescribing mediation, prescribing that people use mediation, and so immediately the question begins to arise if our legislative environment talks about that, then who is a mediator and who isn't a mediator? Kind of who is that entity that qualifies a mediator as such? And more often than not, when that starts to happen in a particular society, the pressure is on for there to be some professional, some mechanism for governing the profession and for maintaining that kind of those gates of entry to the profession, and for certifying, providing the accreditation that a person is qualified, and then finally also providing the accountability mechanism to ensure that people abide by the codes of practice. Now, there are different ways in which mediation can be professionalized, and then South Africa has been on that journey for quite some time. Marion referenced the start of DiSAC, and I must mention in the same breath in NAPFAN, which is the voluntary body that regulates the family and divorce mediation area. In reality, professionalization in South Africa probably started a little bit earlier when you talk about organizations such as where you started, IMSA, etc., and a number of the other mediation and arbitration bodies around. Those were established and they started to provide a minimum standard of training for their members, for people to become a part of their panels, and those organizations served to provide a stamp of approval to those people to say they meet a certain criteria of professional qualification. And that really is the start of professionalization. Professionalization does not have to sit with government. It can very much sit within individual practicing bodies, and we still find, for instance, in the field of arbitration, is that worldwide that tends to be the mechanism of professionalization, that you've got well-established, well-recognized bodies that accredit arbitrators and manage it in such a way. In other industries and in other countries, you find that people move towards a point where there are voluntary collaboration between bodies in a particular country to work towards a common set of standards that they all subscribe to, and that really was what DiSAC and that firm started doing around 2008 to 2009. There was a long process of consultation between the established bodies that provided mediation in South Africa, and the aim of that consultative process was to get to a point where they could agree on a minimum set of qualification standards and a minimum set and a code of practice, and some mechanism for how to deal with people if they did not comply with the code of practice. And that eventually was agreed on, and those standards were published in 2010. And at that point, South Africa effectively had a self-regulatory profession for mediation, a voluntary one, I must add, because there was nothing in legislation that compelled you to become a member of those organizations. But at least there was a point of reference within the industry where people could say that is the agreed industry standard, that is the agreed minimum qualification, and I meet it. And that has been the de facto position effectively up until this day for people to enter the mediation profession. Of course, that does not stop a person from, with no qualification and no training whatsoever, from saying, I am a mediator, and in some cases really believing that they are a mediator. Okay. Now, in a number of jurisdictions, this voluntary framework for regulating the industry is still today the model, where and that especially happens where government is happy to accept what's happening in the industry and to defer to that in terms of the frameworks that it sets for regulation. I think Felicity would be able to give us a bit more detail, but my understanding is that in the UK that is still the way where a lot of this is managed, where there is an industry body that sets a certain standard and government references that on certain mediation programs. And that's the way that it is regulated. I've been involved in this journey for close on 15, 16 years now, and I think at the moment I have very little faith that that particular model will work in South Africa. I do not think so. I think, given the dynamics in South Africa, there is a need for government to have some regulatory involvement in how mediation is professionalized before government will recognize that particular body as being an effective, as being the professional body for mediators. So in that, because of that reality, and I think a lot of people around the room and on the screens have been on that journey, and I think because of that, we started a journey about 6-7 years ago to see if we could transform the work that DiSAC and NAPFAM have been doing into something that is a more of a formal more of a formal professional body that fits within the regulatory framework that governs South Africa. And that framework is established by the National Qualifications Framework Act. It provides for a professional body to be recognized by SAQA, the South African Qualifications Authority, provided that it meets certain minimum standards. And once that professional body is then recognized by SAQA, that professional body can then designate certain professions. That designation means that you can only call yourself by that profession if you meet the qualification standards and you've been accredited by the professional body as meeting those accreditation standards. And so that framework exists in South Africa, and there are a vast number of professional bodies actually already practicing under that framework. I think by the last count, it was more than 120 professional bodies that had already been established in South Africa. And so that's the journey that we started on some years back. We went through a long process of consultation with as wide a net as we could cast with people involved in the mediation industry in South Africa. And about 2 years ago, we established the professional body that is now established as a non-profit company and has been given a specific mandate to set up this professional body and to get it registered with SAQA. Now, that in itself is an arduous journey because you have to establish the professional body and have it functioning and show that it's financially viable before SAQA will register it. So it's not a question of just putting it up and going to SAQA and registering it. You have to start acting like a professional body before SAQA will recognize you. And here the stress that I put there on financially viable. That means there has to be funding to fund the activities of that body. And those activities involve the oversight of the body. It involves the accountability measures. It involves all the other member activities that one typically associates with the professional body. Anyway, so that is the process that is currently ongoing there. And Marion mentioned the work that the Law Reform Commission is busy working with, and I think it's important to reference that in the context of when one talks about the professional body that is being set up. It is clearly envisaged that as part of the mediation bill that's currently being prepared by the Law Review Commission is that a part of that will be that there will be a degree of regulation of the mediation industry. And what the commission did about 2 years ago is it called an experts meeting, and all of the different mediation bodies were invited to that meeting, and the commission distributed a discussion document with all those organizations trying to get feedback about what the preferred model for regulation in the industry would be. And it basically tabled for all the different models that we've discussed already, where there's individual regulation by organizations, there's an industry agreement to regulate, or there's a SAQA professional body that regulates the industry, or that there's a SAQA professional body that regulates the industry in terms of a mandate given under the mediation bill. And then the final option is that the bill establishes a statutory council to regulate the profession. So those are broadly the different options that are being considered by the Commission, and the feedback from that particular meeting was that there was a strong preference for the SAQA accredited model, where such a body be set up, together with there being a clear mandate of the mediation bill about what it is that body is entitled to do in terms of regulating the profession. Now that the Commission's discussion paper is not yet published, but this part of the process was a public process, and that feedback has generally been given to everybody as well. So that much at least we know about the work of the Commission to date. The Commission is busy finalising a discussion document that covers the whole mediation bill, and I think the indications are that it may well be published before the end of the year. Obviously, there'll be another opportunity then for input and for people to make representations about the content of that document. So none of this is finalized, but it is going to be an important milestone for us because we're at that point where the future, in terms of accreditation and professionalization of our industry, is going to be regulated by legislation. Now, having said all of that, if we have a strong preference for a SAQA accredited organization to be involved in how the profession is run, it means we have to make sure that there is such a body. That body has to become functional. It has to be accredited with SAQA, and it has to start doing the work of a professional body. Otherwise, that model of regulating is a non-starter in terms of that legislation. So the clock is ticking in terms of that happening or not happening, and the alternatives are quite uncertain if we don't manage to get it right. Now, hopefully that sets the scene about why it's really important for us to focus on professionalization. I think it will be amiss to not also talk about the obstacles to professionalization at this point. And having been involved in this for much too long, there are real obstacles to professionalization. I think the first one is the reality that very few of us are professional mediators in a full-time capacity. Most of us do something else, and we also mediate. And that makes it very difficult to put the effort and the time and the energy and create the momentum to have a fully fledged profession. If you count people who practice mediation in a full-time capacity, other than within bodies like the CCMA, it's probably, I wouldn't say it's a handful, but it's not a large group of people. So just that fact makes it very difficult to create the necessary energy, but in the first place, but probably more importantly, it makes it difficult to create the financial impetus, give you the financial impetus to make this happen. Because that's the second biggest obstacle is money. It costs money to establish a professional body and to run it. And the big question is how much are people involved in a part-time profession, how much money are you prepared to pay to have a profession? Because that is going to be the crunch question. This organization is going to come to you in a few weeks or a few months' time and say to you, if you want a professional body, that this is the financial commitment we're going to want from each and every mediator. And then the question is going to be a personal one that you have to answer. Is it worth my while to put money into making this happen? Or am I happy for somebody else to regulate this profession. I think the third real obstacle is that such a professional body requires collaboration. It requires people who have been involved in doing their own thing for 20, 30 years to collaborate and in some and to a large degree give up their autonomy and give their autonomy in terms of the standards that they are currently setting. They have to give up that autonomy and agree that now goes into a pool where there's a delegated group of people who are setting standards for all of us. So that's a big step, especially for organizations that are well established and that have a passion and a belief in the worth of the work that they're doing. It's a leap of faith to create and put your trust in a group of people who now have authority to take that out of your hand and carry on with that. I think just a final point there is that, and this comes back to one of the first points that I said that I referred to, is that for a true profession, generally you require prolonged formal training. Now that's probably a sore point as well when it comes to mediation, and that we're looking to become professionals on the basis of a 5-day course. Now that doesn't sound very professional. So part of becoming a profession probably means raising the bar in terms of qualifications, in terms of the standards that we set for ourselves, and in terms of kind of the career paths that we create, not only for ourselves, but for people who follow in this industry. People need to be able to aspire to much more than having a 5-day qualification, and they need to see how their career is going to develop when they enter this profession. So let me stop there. I think in summary, there's a lot of work to be done, and there are some hard questions to be asked and to be answered on this way towards professionalization.
Thank you, Hendrik. Thanks so much. Over to you.
Right. Let me have some water first. Well, good afternoon to everyone, especially those who are online. Those who are here present. Thank you for inviting me. Regrettably, I do not come bearing gifts. A lot of what I'm going to say is displeasing to me, and I imagine will be displeasing to you as well. Because, in a word, if we look at where mediation as a option is going in mainstream litigation in the High Court, there are very few fringe mediation in the corner. And there is more lip service paid than actual action taken. That's the blunt reality within which we work. I was interested to hear what Hendrik had to say about the Law Reform Commission. My chief, the Judge President of Gauteng, and my counterpart in Pretoria, Deputy Judge President, both sit on that committee. When last I had occasion to raise this topic, Obi Lwaba said to me that nothing had been done for a very long time involving him or the jail, and they were thinking of asking for a meeting, which was a piece of information that led me to draw the inference that there wasn't a great deal of energy, but in fact, I haven't seen anything in hard terms other than the meeting which produced the memo which Hendrik referred to back in 2021-22. Now, what are we really talking about here? From the judiciary's point of view, the courts are a potential market, looking at what action might be taken by professional mediators to develop the market for those services. And the High Court particular, to a lesser extent, the Magistrates Court, is a market site. So let me articulate three things. What do the judges want? What have the judges done? And what might the judges do to develop a mediation model? So let's just have a look at the environment that's already in existence. I'm not going to burden you with reading the statutes. First of all, we have Rule 41A. I might add, Marion very generously, when wrongly, suggests I had anything to do with 41A. I completely disassociate myself. I have to confess that I was on a task team that produced, ultimately became 37A, although what we gave the Rules Board rather resembles what an author does with a novel, then gives it to the movie makers. But not much to recognize after they've reworked what they want to do. I think Rule 37A is glaringly timid, and the same thing goes for 41A. Let's just see what judges are supposed to do. First of all, 41A tells you that you can't issue a valid plea unless to redress mediation and say you agree to it or not. A judge under 41A3B may direct the parties to consider mediation. And then there's this 30-day deadline that runs when, if nothing happens or nothing meaningful happens, that's an end. 41A references 37A, the case management process. There, first thing you have is each judge president will designate a category of work in the division where 37A will apply. Back in 2019, when this was promulgated in Gauteng, JP designated all personal injury. A year ago, we abandoned that. As we sit here now, the only category of work which is routinely referred to case management is commercial matters in the commercial court. It's part of that particular process, which accounts for a very small proportion of the work done in the division and excludes all personal injuries. And then 37A5A, where you have a category which is case managed, you need a certificate which the judge is required to address all issues amenable to be resolved without a trial, which is a long way around of saying, have you mediated? And then lastly, what the judge is supposed to do in the case management process in 37A11A is to explore settlement, where there's an express reference to the parties considering voluntary mediation. So as I say, both those items in the rules are timid. In the Gauteng division, there is a family court in both seats. And in the Directive 1 of 2004, paragraph 29, the family court is dealt with. And in that directive, it is stated that if you want to bring an application of any kind in the family court, your affidavit must, in a distinct area, address the question of mediation. And what has been written in there is that the judge is expressly given a discretion to stay the proceedings and demand explanations as to why mediation has not been attempted. And at any time, I request the parties to consider it. Again, because it needs to be consistent with the rules and not add any substantive legal obligation. It's timid, but has at least one little tool that it can hold up the proceedings by a stay. Whether that would pass muster if it was challenged after V-raise is a question I leave open. What none of these three instruments say anything about is cost penalties. I'm sure all of you are familiar with the case law that's been evolving in England and Australia and New Zealand, where courts are being used as a stick to add to the carrot. There is nothing on the horizon in our jurisdiction to suggest that. Even in the magistrates' court, where there is a court-annexed system provided for in those rules, there again, it's a timid provision where the magistrate can simply ask the people to agree to go off and try mediation. So that's the rather flaccid statutory basis upon which we've got to work. When I was asked to speak at the seminar, I sent a note to all my judges to ask them if they would tell me what their experience had been in the last couple of years with Rule 41A in the guise that I have described. And the answer was zero. Hasn't had a light shone on it whatsoever. As a matter of fact, the reference in the pleadings is simply a ritual. I don't believe anybody really engages in anything other than do you agree or disagree? We disagree, on we go. So that's been a dead letter. So what have we done in Johannesburg? We've put what I've described into our directive, but it's really been used. The family court has been one of our successes. We've managed to stream all the family courts into what is effectively a 4-week cycle. So you almost eliminate entirely urgent matters. And as a result of being able to get your matter into court on 4 weeks' notice, there's been a huge take-up dealing with matters at that stage. The dynamics of family law litigation is an oddity. In Johannesburg, a divorce trial is a rarity. If we have 20 in the year, that's all. The real site of family law litigation dynamics is not in the trial. It's in all the preliminaries. And the Rule 43 application has become the true site of struggle. Once you've fought and won and lost, that pretty much wipes out anything left to talk about. That partly because of opportunity to get more than discovery in the financial disclosures, which we pinched from Form E in England. That's about all I can say we've done. Is there an appetite on the part of the judicial to do anything about mediation? Frankly, no. There are some judges who have had personal experience in mediation. On my bench, there are at present only 2 ex-IMSA members who have been in the trenches on mediation. The rest of my bench had no background in that prior to coming into practice. And some of our judges went to Utah a few years ago to get trained. But, of course, the judges are not doing the mediation. And here comes, I think, the critical intersection with what Hendrik's been talking about. If we're talking about a market at the site of the court for mediation, one of the issues that needs to happen is that there needs to be a recognizable pool of credible mediators who are available on short notice. So everything Hendrik has said about evolving a professional recognition model is critical to any credibility that mediation will have as an adjunct to the court process. What the judges are interested in, and especially me, is diverting caseload away from the courts. It's critical for a whole range of reasons which have nothing to do with the merits of mediation. I have now said it on a number of platforms, is that running the Johannesburg High Court is now a triage exercise. There is simply not enough bodies to do the work at a rate that is anywhere near respectable. A trial date lead times are 3.5. You cannot have a commercial transaction in paralysis for 3.5 years. You cannot ask someone to wait for their divorce to be heard in 3.5 years. At least of all, with her children, because she's waiting damages for her deceased husband's accident, to wait 3.5 years. So it's intolerable. I have been punting as recently as Monday that the organised profession in Gauteng has to start taking the initiative collectively with the state and with any other actor that is relevant to start diverting work away from the court. Best will in the world, even if one of us was to become Minister of Justice this afternoon and was agreeable that I can have what I need, which is another 20 judges, that minister would have to go to the Treasury and say, please give me the money. And the answer would be, look into the purse. There is nothing there. So we are low on the food chain of what public money is going to be spent. It's a grudge expense in any event. And even if they did give me 20 judges tomorrow, it'll take me 5 to 7 years to recruit an additional 20 judges. We have to replace half a dozen a year anyway, because Gauteng is a nursery for the higher courts. We are losing senior judges at a rate that we can't mention. So the desperation, not using that word simply for effect, it's a practical, appropriate word to use. The desperation I experience to try and ameliorate what is an utterly moribund litigation model in Gauteng demands that there's got to be a diversion. Mediation is one option, arbitration is another. I have suggested to the organised professions that one of the options that I see is that if the Arbitration Act was amended so that one could buy in a full court appeal, which is of course counterintuitive to conventional arbitration, it might open up an additional market for arbitration. We can't hear 100% of the cases, but we could hear 10% of them that go on appeal. So those are attempts I've made to satisfy what the judiciary requires. Which comes back to us here today. There simply has to be enormous energy devoted to making mediation credible. It's not so much that the judges are hostile to mediation. I don't think I've met anybody who's expressed that outright. There is an ignorance, there is an indifference, and there is largely an attitude that someone else must provide the resources. And among others, clearly, people sitting around this meeting need to be the movers and shakers on that. If you think about what the marketplace for mediation is, that is otherwise going to happen, let's just look at what is actually happening. One of the major areas that gobbles up a great deal of our resources are personal injury. What it seems to me is an important innovation in Africa is to what the rules board left out of our original Rule 37A proposal, which is to move to a single medical expert model, so that you do not consume fortunes of money on people arguing over whether or not the medical condition is A or B. That is part and parcel of an overall strategy. When it comes to mediation in medical negligence matters, who has the skills to do mediation? If you're talking about a brain injury, you're not going to get a mediation on a clinical assessment by someone who doesn't have subject skill. One of the things that was apparent 30 years ago, when in IMSA we got ourselves involved in a DRASA and later in AFSA, the marketplace for mediators is segmented. So you can't approach it on a one-size-fits-all basis. In the early days in labor relations mediation, middle management didn't know how to talk to people. Or bluntly, white managers didn't know how to talk to black people. Thought that black people had anything to say, something they had been taught. And so when IMSA came into the marketplace, as soon as it achieved a market credibility, ignorant managers and equally untrained and unfamiliar unions were happy to eat out of our hands. As time went by, as more and more people acquired proper negotiation skills, the dynamics of that market evolved. When we tried to shift the IMSA model into commercial mediation, one of the first things that became apparent is that if you offered the mediators, Roland Sutherland, who no one had ever heard of, the commercial captains of industry were not interested. They wanted somebody who grounded us. They wanted Mervyn King. And you need to understand those aspects of how the market moves along. And also, to come back to my point about personal injuries, a lot of money has to be spent on a personal injury matter in order to know what you're fighting about. The notion that you can come in before the summons is issued and mediate, that simply can't exist, because at that stage, no one knows what they disagree about. So you're talking about a marketplace that is looking for mediators who have to come in and stop the bull from mounting, and yet add then. That needs to be looked squarely in the face and dealt with. In the commercial area, as I've said, there's the gravitas factor. And also, let me make it quite blunt. Are there any attorneys sitting in this room who have been litigated? Hands up. 1 out of 30. Until the litigation attorneys are in this room, you will not convert the litigation market in this city. They have to buy in. Doesn't matter how clever, how rich, or how insightful the clients are. The litigation attorneys will drive or kill mediation in the commercial sector. And if they're not on board, one simply will not be able to create the market we're talking about. And family mediation, of course, that was around a generation ago. That is well established. And one of the characteristics, generally speaking, there are exceptions. The attorneys who work in that field all have a soft skill set. I mean, soft in the best sense, is that they're able to inject empathy into the way they deal with their client. I think of one attorney, but no, that's a different story. You can see that you have to match soft skills to the particular market segment that you're dealing with. One of the things that has become clear is that there are certain issues which presently are required to be dealt with by litigation, which are unlitigatable. Evictions. There's hardly an eviction of any large body of people that doesn't end up in a years-long agony. And what's the big hock click? Big hock click is that local government will not budget money to provide alternative accommodation. You can case manage that to your heart's degree. You can drive judges absolutely insane. You can beg, you can borrow, any kind of threat, costs order, whatever it is. Frankly, it's unlitigated, and the scale of it is enormous. I don't have figures for the magistrates' court. There are a lot of evictions taking place. But clearly, in Johannesburg alone, there's a need for a specialist evictions court. There's no prospect of such a thing taking place. And for those of you who are paying attention to the legislative changes in the land court, in its new configuration, it's now going to be dealing with evictions under ESTA. It's the rural evictions. They don't have jurisdiction to do high evictions yet. Somebody in Pretoria thinks they'll have the capacity to do that one day. I've spoken to the judges on that bench. They're terrified of the prospect because of the capacity you need in order to deal with them. It's just way out of kilter with what's on offer. So there are markets which need to be developed. And I think the big point to recognize is that although no one in any of the courts here or anywhere in the rest of the country, I'm bound to say, are going to do a great deal of work by way of taking the initiative, other than talking up mediation, there is room to develop these markets. Professionalisation is going to make a huge difference when there's a recognizable pool. And what one needs to do, obviously, is to get the heads of court on side, wherever that needs to be done. So let me sum up, as I understand the status quo. From the judiciary's point of view, our self-interest, our commitment to the public interest, requires us to divert caseload on a huge measure across a wide range of matters. In order for that to happen, we need to modernize thinking about dispute resolution. I've been making my noises wherever I've had the opportunity to do so, but that needs to happen at a lower level. We need to convert litigation attorneys to embrace mediation as mainstream dispute resolution techniques. And then I've already made the point about the segmentation of markets, but here's the real elephant. And this is what I get told when I speak to litigation attorneys directly about mediation. Who's going to pay for it? Where's the funding coming from? It's an extra cost on top of the litigation. Who's going to pay for it? Where's the money going? And there it is, really in a nutshell. We can have a pool of mediators. We can have impeccable credentials. We can have market credibility. But if there's no money, there'll be no one available to take that. And that is a problem for which I can offer no solutions. But it's there, staring us in the face. Funding. And I think we need to look holistically at what we're trying to embrace. I've had occasion in recent times to try to make the argument that mediation has been ill-served by some rather superficial arguments in its favor, like it will save you money. It won't always do that. And it's actually not sensible to pretend that it's always going to save money. Yeah. Give you a very practical example. The MEC for Health in the province of Gauteng is looking at spending more than half his budget on damages because his doctors either kill or maim babies, was ecstatic about having mediation built into the number of claims made against the department because they think it'll save money. And then they engage consultants at whatever they charge in order to manage it for them. Frankly, that entire project has chugged along without really much effect, notwithstanding the fact that the South African Association of Medical Mediators has got credibility with the department. That was the hinged effect of that overture to them. So there is one concrete example. There may be others I'm not familiar with. where funding is exactly the problem. So let's not overdo selling mediation cheap. It can be quicker, but what one's got to also do is make the point that the technique itself has intrinsic value. It's not just a plan B. It can be a plan A because of what it can do. And I think that's a shift in the mindset, both from within the mediation fraternity and from the consumers of that service, that needs to be given greater attention. It's not the poor man's alternative to litigation. It's a proper option on its own merits. People need to understand how to use it. So, having shared my despair with you, I'll leave it at that.
Thank you very much. So both of you have really shared your challenges with us. I guess let's go into the questions, comments, kind of part of the meeting with that frame of mind. I mean, any questions, any comments? Yes. Hi. Sorry, that's Chris now.
Yes.
Hi, Chris.
Hello. I have the dual hat as also being an advocate at the Joburg bar. And I was quite intrigued by the comment that the attitude of litigation attorneys must change. But to what extent can the attitude of advocates assist in? I think from but maybe drawing more folks into mediation. That's a question that I have. Because I know from an advocate's perspective that it helps to be able to advise a client and attorneys when a given time you need to mediate a dispute with someone I've done that. But yes, sort of just maybe if Judge Sutherland has a comment or an idea on how that should be used to. Right.
Should we take a few questions and then get back to Hendrik and Roland to respond to? Yes.
So yeah, I've got a few questions. Maybe one comment. I'll start with the comment is that I can attest to the fact that it's been very difficult for me as a litigator to convince my counterparts to refer matters to mediation. It's almost impossible. There's I can say very clearly that lip service is being paid to Rule 41A. There's a standard response. We reject mediation for the following standard reasons. Parties are unable to settle, and some, there might be a few others. So that's the comment, is that I think that there's something to be said about litigation attorneys almost being against mediation as one of the avenues of dispute resolution, particularly in commercial matters. Questions I had is particularly on Rule 41A. There's now a proposal by the Rules Board to take away Rule 41A9, which I think is the only potential motivators for attorneys, particularly, to maybe advise their clients to consider mediation as an option, is the potential of cost reduction. With either the refusal or the proposal to refer to mediation being taken into consideration at the point where costs are considered by the judge. The proposal now is to take that away because the argument by the Rules Board is that it detracts from the voluntary nature of mediation. I don't agree with that. I think that it's, that carrot and stick approach, and that's an important mechanism that should stay in place. And then I just have a question on the professional body. What is the professional body that's currently in place? What's it called? And what exactly is the mandate? Who do they represent? How wide is that net? Because I know all the voluntary bodies, and it almost being each representing a particular segment, with something like SALMA, which are then bodies like dynamics and mediation and motion, etc. So what is the status there?
Right. Sorry. Your hand up. Do you want to add a couple of questions?
Yeah, an observation is, Judge Sutherland Roland has spoken about how really there's no understanding, appetite, resources in the justice system to accommodate mediation. So if that is a horse not worth flogging, then what do we do to influence attorneys and advocates? Because you know, I wonder if it's a question of whether they don't understand mediation. Do they regard it as a sign of weakness and a loss of control of the client? Do they think it'll expose flaws in the advice they're given to the client? Or is it simply about losing income? So, you know, how do we influence the gatekeepers, who are the attorneys and the advocates, that it is part of their responsibility to their clients to present all dispute resolution options and, you know, to canvass those seriously with their clients? Thanks.
Okay, there's another question on screen, someone with an iPhone. Felicity, we recorded yours.
Thanks. It's Aslam Musaji. Just a few comments. The one is, I think the DJP should be congratulated for the fact that he's being transparent and he's keeping us informed of the lead times to get dates for particular types of matters, because that's often the discussion that you have to have with the client in order to motivate the client that the matter is ripe for mediation, or we should consider referring this to arbitration. The second comment that I have is that I still think that many litigation lawyers don't appreciate and understand a mediation process. They see it very much as a privatized court process and like an arbitration, whereas it's a completely different dispute resolution mechanism. And we need to find ways to get more people to understand what commercial mediation is about. And I also think that the promotion of mediation / arbitration needs to run in parallel with experienced attorneys and counsel in the profession, making themselves available for acting appointments so that we can resolve or shorten some of the long lead times that the judiciary is currently facing.
Okay, great, thanks. Roland, would you mind dealing with the issues around Rule 41A9 and then the questions about how we influence advocates and attorneys, and the timeframes that Aslam's just mentioned, and then we'll move to Hendrik to speak about the professional body.
Right, let me deal with them in logical order. 41A9. I'm not sure if it matters a great deal one way or the other, quite frankly. Such a timid provision anyway. If we were going to adopt the policies which found favour in the English courts, and I think we must be careful not to exaggerate the cost orders that we made in the English cases, which we're all familiar with. All quite very special circumstances. They are certainly encouraging. So I'm not sure that necessarily is a ground point, so to speak. As far as advocates in their attitude towards mediation is concerned, it doesn't matter as much as with attorneys. The advantage of an advocate who is sufficiently familiar with mediation to advise their clients meaningfully that this is a good option. It's obviously a big plus. As you asked the question, I have it in the back of my mind that there's a provision in the Code of Conduct which requires practitioners to introduce the notion of mediation to clients. Can't call it to mind. And certainly, even when I was at the bar 12 years ago, it was then considered the appropriate thing for a responsible counsel to give attention to that prospect rather than just stumble on it. So it's useful, but it pales into significance in comparison with the attorney. That brings us really to Felicity's point. I think the principal reason that attorneys who are not just concerned about the money, and no doubt that is in some cases the only concern, is that if you are representing a client who you intend to keep, you need to have some self-confidence yourself in embracing the process that you lead them into. And if you are unfamiliar with mediation, then there's no way you're going to want to take your client into that environment. So overcoming ignorance is obviously step one. That doesn't mean to say that once you're familiar, you like what you see. One of the problems with mediation, the very golden thread of everything Hendrik said today, is achieving a level of expertise that is visible to the consumers. A litigation attorney who has been successful in the litigation mode and who now wants to learn a new set of skills has to be as confident in that skill set as he is in his litigation. That doesn't happen after 5 days of training. So there's I think, a big uplift there. But there's another issue, particularly with litigation attorneys who are successful. That is a psychological block that if you bring a mediator, you're effectively now in a deferential mode to another profession who is dictating the pace of how this case is going to be dealt with. I think those attorneys who can't cope with that differential dimension to engaging a mediator are never going to be able to embrace this with any confidence. And there are lots of other rude things one can say about attorneys too, but we can stop at that stage. It is a mindset issue. You can roll out all the facts, but if you're not the marrying kind, then there's never going to be a ring put on your finger. So, you've got to get the mindset ready for that particular kind of process. And that's tough. We haven't started trying to do that now. Efforts have been made one way or another. IMSA, DRASA, EFSA, TOKISA. It's a churn of generation. And we're still pumping out young attorneys who are not embracing it. So, that's the point. The old guys, don't worry about them, they'll die soon. But you need to convert the 30-year-old and create the market for the future. So one of the things I suppose one could do is to engage the academics. I've seen academics amongst us here today, they're usually quite a lot. In the law schools, mediation has to be made respectable. And although mediation skills are not what I advocate universities being responsible, any more than I am particularly fond of the idea that the faculty should assume some kind of professional training. Not equipped to do that, and the people who go there to lecture don't have the skill sets to make that transfer. But mediation has got to find its way into the academic syllabus as well, in order for it to be perspectivalized. In much the same way that one of the most astonishing lacuna in almost all law faculties is the absence of teaching ethics. I don't know why it is. We're not in the backfelt of the world legal environment. We haven't even got to the backfield when it comes to ethics. And those are all symptoms of an incredibly narrow focus in academia. I mention this because I think that's an area where if you've got friends on the inside, you could go with it. But just to give you a sense of despair I have with the universities, I had occasion at my alma mater discuss with the professor in charge of evidence course told me that it had been dumbed down to a 6-month course. They're doing just selection. LLB that can't take the law of evidence seriously is not being designed by people who are trying to prepare people to go into practice. It's actually a shame. So there's a lot of work to be done there, and on the mindsets of attorneys too. I dare say many other things, but those are the ones that I'm acutely conscious of and unhappy about.
Thank you. Thank you. Over to you, Hendrik.
Yeah. Okay. I think just before I address the question on the professional bodies, just to give some reassurance about the work of the Law Reform Commission. There have been 2 sittings of the Commission this year already. Progress the discussion document, and the 3rd meeting for the year is actually planned for July. Judge Mlambo has resigned from that particular committee because of time pressure, but Judge Ladaba is very much involved and an active member of all the discussions. So there was some delays last year because a new researcher had to come onto the project, but I'm happy to say that good progress is being made this year. Okay. In terms of the new professional body, it's called the Association of Dispute Resolution Practitioners of South Africa, and the status of that organization is that it was established by way of a founding meeting between and the founding members of that organization are 12 of the well-established mediation bodies in South Africa, including all the ones that you mentioned there. So they all have collaborated. They were all part of the consultative process, and these bodies all applied to be founding members of the professional body. And so there was a formal resolution to establish the body, to adopt a MOI, and to appoint a first board of directors. And that board of directors now has a mandate to develop that organization up to the point where it becomes a functioning professional body. It's a long way from actually being there. So for the time being, the founding members very much are still holding the torch and doing the work that they are doing, but they are collaborating in that process of transforming the regulatory functions into something that fits the SACMA model. Remember, within the SACMA model, you cannot apply as an organization that represents mediators, so SAM, KISO, conflict dynamics can't be members of the professional body. The members of the professional body are individual practitioners. So that is the big change that has to happen. That does not mean that all these other organizations fall away or that their role changes. Their role absolutely continues, because one of the critical things of a professional body is that it cannot provide training, and generally, so that's not its role. These other organizations are very much going to continue doing what they do, continue to have the panels of practitioners that they promote and that they manage, but the functions associated with the professionalization and standard setting and accrediting will eventually be taken over by the level.
Right, thank you. Last round of questions. Duncan.
Thanks. I've got questions for both of you, if I may. Hendrik, just on the exclusion of work. So we've discussed who qualifies. The tricky bit is going to be, what are they qualified for, and what are those unqualified excluded from doing? And it just seems to me that is going to be a very difficult thing to define and a very difficult thing to police. And I mean, my view, for what it's worth, is that we shouldn't be too particular about that aspect of the professional organization. What we should be doing is providing levels of competence that attract people rather than rules that exclude people. So I mean, that would be my suggestion, that that should be the first focus, because the problem with mediation is it's so difficult to define. What are we going to say to somebody who's in a indigent environment where two people are in dispute, that the third neighbor is not allowed to mediate the dispute? So, you know, and there's a continuum. So, and you've got all sorts of organizations that try to exclude work, and it's generally unsuccessful, and can't put the perpetrator in jail. So it's quite difficult to manage. So I do think we should try and be excellent rather than exclusionary. The other element is the one that Roland mentioned, is that there are horses for courses. I know there are a number of mediators, probably some in this room, who think there aren't, that if you're a mediator, you can mediate any dispute. I don't share that view. But okay, so that was just for Hendrik, and perhaps you can comment on the exclusion. And then for Roland, just on the, to my mind, and I've looked at it a lot, it's the economic model that is the biggest obstacle to making this work. You mentioned it. So you say it's who's going to pay. I think it's bigger than that. And the way I think that cooperation between courts and professionals can operate is if we can identify thresholds or doorways in the court process where mediation becomes a fast track. I'll give you an example. In China, they pay to go to court. If you want a commercial dispute resolved in court in China, you've got to pay to go to court. But if you mediate the dispute before it gets into proper litigation, you get half or 3/4 of your court fee back. Now there's a real incentive, because the litigation process costs money, mediation gets you reprieve. So all of a sudden, mediation is popular. The pleadings are closed, so everybody knows what the dispute's about. You can get your court fee back. So, I mean, we've got constitutional barriers to that, but we might get creative. The second element is that for example, in the commercial court in England, you can't get a trial date unless you've had a mediation. So in the commercial court, you have a series of pleadings exchanged, then you have witness statements exchanged. So they have a witness statement process. So now everybody knows everything. And the court says, now that everybody knows everything, you can only have a trial date when you've had a mediation. And very often that mediation, if it doesn't resolve the dispute, it resolves 80% of it. So that which is placed before the court is now properly identified, clearly articulated, and it provides a sort of filter process. So to my mind, if the court process has a series of thresholds, wherever those thresholds are, that the court won't do step next or won't fast track step next unless mediated, you may be able to clear roles there. And then just lastly, I don't think we can solve your problem unless we get the MEC and the RAF on board. Sorry, bit of a speech, but
I maybe
Thanks.
a question or comment on Duncan's. I just want to simplify mediation in saying that the mediation to work needs a bona fide dispute, and it needs a carrot or a stick or both. And if one party doesn't have a carrot or a stick and there's no bona fide dispute, then you can't mediate. If you think of your straightforward debt collection matters, those sort of matters, they can never be mediated. And now, sometimes the carrot, unfortunately, in our system, the stick for the one party is the cost and having to wait 3.5 years. The carrot for the other party is that he doesn't have to pay within 3.5 years. So if we can streamline the process to you get rid of the almost the undisputed, the unbona fide dispute should be dealt with quicker somehow. And if we can expedite, make the 3.5 years shorter. So what I'm trying to say is that, is it not once we fix the bigger system, then mediation and arbitration that the bigger system supports will find favor. But as long as there's problems with the bigger system, it's going to be very difficult to support mediation and arbitration. And to maybe also give an example, if we have a arbitration construction court that really supports the arbitration process, where you don't in an arbitration process get stuck in a court process, more people will be willing to use arbitration also, because the process is protected by the courts. So we need 20 judges, but if one of those judges can be a construction and arbitration judge and get rid of all those arbitration matters, then one can maybe do, it's in a perfect world. I know that works in England, but the real question really is, unfortunately, right, should we not fix your system first to support the others? And we're trying to work from sort of pushing instead of pulling somebody up. I don't know. That's a question.
Thanks, Rian. Felicity, you've indicated, and I'm afraid I'm going to close the floor then, just in terms of questions, and just give Hendrik and Roland a final opportunity to respond.
Yeah, I just wanted to support what Duncan said about not defining mediation too narrowly. And I think there's been quite a bit of discussion about that. You know, is it only a certain kind of mediation? Is it only civil and commercial mediation? The experience in the UK was that the Civil Mediation Council, the voluntary body, started off with a focus on civil and commercial. But then people who were civil and commercial mediators said, but I also do workplace, and I also do family, and I also do community. So why aren't you regulating that? Because we have a lot to contribute to developing standards, and you know, why have these conversations in multiple organizations? So the CMC then established really a broader church, and so it's civil and commercial plus workplace, but you have to prove your qualification and experience in that area, plus community, plus education, because there's a huge amount of mediation in education, plus family. You know, so really saying we are about consensus building. We are third parties who intervene in a conflict or a dispute to facilitate the parties arriving at an outcome. Some of us do it evaluatively, some of us do it facilitatively, some of us do it transformatively. That doesn't matter. We're all about consensus building. So I would really support what Duncan has said.
Great, thanks, Felicity. Can I give you both the opportunity to wrap up? Yeah.
Okay, yeah. Duncan, thank you for your question. I think I'm going to start with the second question first, and that's one around different horses for different courses. And in a sense, Felicity has also pointed at the direction towards that being the correct model. And I think we firmly are in support of that, to say that not all mediation is the same. I think that there is kind of a general skill set that underpins a lot of it, but there's a lot of additional skills that need to be acquired in specific practice areas before you are effective in that practice area. So in terms of defining standards, there certainly is an awareness that there has to be differentiation. Already you saw that being recognized back in 2010 when we established two bodies, one for family mediation and one for commercial mediation. So even back then, there was that recognition that we couldn't just have one set of standards. Those two bodies did collaborate in terms of setting the standards for kind of the minimum skills training. And certainly I would hope that kind of points the way forward, that will continue to work like that, where for each practice area, you've got professionals in that practice area who can provide the guidance for a particular set of qualification and accreditation standards that is suitable to that practice area. If I then move to your second question, I personally think that it is important that when we get to the point of designating professions, we do it in quite a specific way that is aligned with specific practice areas where there's a need for a pool of qualified people to be recognized. Where there is such a need, those are the areas where we should designate a profession and be clear about what is required in order to enter that specific pool, which has a use in those areas where that pool is required. I personally don't think we should go the way of saying mediation is a profession, and unless you've done this training and met that criteria, you can't call yourself a mediator. I think the reality is that there are a lot of people doing mediation work in an informal context, within a community context, within church context, within family context, and by that I don't mean family law, who are doing mediation work and sometimes not qualified, but still doing good work, and sometimes in circumstances where just their exposure to the work that they've been doing gives them that expertise and experience, and we would not want through a process of professionalizing be inhibiting those people to carry on with the good work that they do. I hope that answers your question.
Thank you, Hendrik. Well swooped.
Yes, if I can deal with the theme that Duncan's put on the table. Essentially, we're talking about what role gatekeeping could play in directing people in one direction or another. So let me give you an example of what has actually happened. Bill 37A was promulgated in June of 2019. And at once a protocol was put in place in Johannesburg, which constituted a gate on all personal injury matters. You have to first come before a judge and demonstrate that your trial was apple pie ready. Then get a ticket to go and have it set down. What happened, of course, is that suddenly there was a shrinkage of the role, and the lead time of the trial role somewhere between 12 and 14 months. But what had really happened was there was a huge queue behind the gate, couldn't get through it, especially in the first year, when almost without exception, the threshold standards which were set for getting a ticket to get a court date weren't met. We don't have to go into why that wasn't so, but we held up hundreds, if not thousands, of trials. And that was our system until 18 months ago. So in the first 18 months that was done, was there an uptake in mediation? Couldn't get a trial. Bounced back time and time again. It had absolutely no effect on diverting. All people did was just wait in the queue and eventually get it right to go through. One of the reasons why we've run away with lead time is because we had to abandon our case management, our bulk case management model, because in the RAF matters, nobody turned up. With the RAF, couldn't have a discussion about getting ready. Plaintiff had no one to talk to. You couldn't tell the plaintiff, well, I can't give you a date because the other side won't turn up to deal with this. And of course, there's the flood. So I'm not convinced on admitted some limited empirical evidence that gatekeeping is particularly effective. One of the things that's been evident in an analysis which I've done since 2019 is to compare the process issue and the enrollment dynamics on comparative profiles. So consistently from the middle of 2019 until now, something like 75% of all process issued in the Johannesburg High Court is in business commercial matters. 6% of the trial role are those commercial matters. So what happens to the others? Some civil matters never go further than the summons, they get settled, they just fade away. Some of them might end up on the unopposed motion roll as default judgments. But the amount of work generated at the process issue level is not reflected at the enrollment level. Road accident fund, 6% of the process issue and 80% of the roll. Why is that? Because you've got a road accident fund defendant who is fundamentally dysfunctional and can't settle anything. And those dynamics are part of what bedevils us. If the new Minister of Transport, whoever that person may be, bless him or her, can actually bring rationality to that environment, it will be the beginning of a sea change. But as long as we have to work within the confines that are within our own range of powers, we can't overcome those problems. So, ultimately, you are going to give us the last word. Let me say this. I used to say to the kids when they were little, whenever they struggled with something, do you want to grow up only to be able to do easy things? And I get the appropriate answer, and then I say, and I think that's a motto for life. No point in being here if you're really interested in doing something easy. This is bloody hard. It's going to take a long time. But if you're committed, then, kijk noord and volg die route. So,
I think there's another way of ending that.
Feels that way.
Thank you very much. So I will have the last word, but on that, thank you very much to Hendrik and Roland for coming and just really having this conversation, giving us your expertise and your experiences. And it does sometimes feel very, very hard, absolutely, but we all are here because we're interested. There's nothing better than settling a mediation. We know that it'll keep your endorphins high for weeks afterwards. And there's a lot of work to be done. So yeah, look for the market, make sure we continue professionalizing this sector, I guess, and also very much a challenge to us as individual mediators and mediation organizations to keep up the good work. But thank you very, very much for your time. And please help yourselves to a drink. Sorry to the people online that we didn't have Uber deliver the drink to you, but thank you for joining us anyway online, and please hang around if you're here to engage more. Thank you.